On Radio 97, our resident lawyer Despina Priala from boutique law firm Priala Legal in Runaway Bay with us each and every Thursday. She's here to offer legal advice by providing some general advice on the latest of hot topics. She has experience that spans more than 25 years in areas like property and commercial law. She also produces wills as part of estate planning and litigation. She's with us once again. Morning, Despina.
Good morning, Wayne. Good morning, Brooke.
Good morning, Despina. So this morning we'll be discussing something quite interesting that we haven't touched on in a little while. Deceased estates, some laws and unknown facts, I guess we'd like to say. So first up is the Forfeiture Rule. Did I say that correctly? Forfeiture Rule.
You did, the Forfeiture Rule. And so, again, I will say as a little intro that I'm continuing to get feedback every week from listeners on social media and just emails, and it's great. And what the listeners have said to me consistently for quite a few months now is that they love to hear about everyday experiences and encounters that they get involved with or have been in the past or are currently in now that we talk about on the show. And this is another example where they may not know the name, Forfeiture Rule, but when we talk about it in a minute, they will probably say to themselves, oh, yes, I've heard about this, I've come across it, or I've read it in the newspapers, and now I know what that means if I'm ever in this situation. And this is what we do on the show. We explain to people in simple terms so they can understand, because the law is very complex, what these terms mean. And this is another classic example, the Forfeiture Rule. What is that? So when someone causes the death of another person, and this is in Queensland, we're talking about common law here for the moment. What the common law says is that the perpetrator cannot benefit from the death. So the idea being, of course, that no one should benefit from his or her criminal act. And that's called the Forfeiture Rule. So in Queensland, we have the common law. Now, in other states and territories around Australia, there is statute that represents a similar or all the same thing. It's just under legislation. But we can get into it a little bit because, as I said, the listeners out there might have heard about this where someone's been charged and then perhaps convicted of a criminal act. So, for example, they've been charged with murder or manslaughter, and the people say, well, he was to stand to benefit from the estate of the person that they killed. Do they still get that entitlement? Do they still get to benefit? And logic says, well, no, they shouldn't get to benefit if they've killed someone to then benefit from their estate, for example. And this is what this rule says, the Forfeiture Rule. So let's talk about it a little bit more. So when we apply the Forfeiture Rule, then we talk about how it may play out in a deceased estate. So we're not just talking about someone named as a beneficiary, although that's the primary, I suppose, scenario where someone perhaps is convicted of killing someone, so convicted of murder or manslaughter, but they were the primary or the sole beneficiary. But it also applies to other situations where that person might be named as an executor in the will. So then that would remove them as having that role, which is a very important role in administering estates. It could also apply to just gifts in the will, not necessarily all of the estate or money. It could be just a gift in the will.
Yeah.
So that would be removed. But also, what about entitlements to superannuation, death benefits or insurance proceeds? So it can apply across the board. So if you come back to what we said earlier about this rule is about ensuring that someone cannot benefit from their own criminal act. So that would apply across all aspects of a deceased estate and an inheritance, or whether they were appointed as an executor and trustee of that estate, or whether they were going to stand to inherit separately proceeds from a superannuation or a life insurance policy. So that person or persons, the rule says that they cannot benefit from that. And as I said before, it actually makes sense, doesn't it?
Does this law come up very often? I mean, is it how often would you see this being taken to the point where there is a question about whether this person should actually get the proceeds of the will?
Yeah, it's a good question, and it has come up quite a bit over the years. You see the headlines where someone's been charged, they're not convicted yet, and then they talk about, well, we then discover that they were the sole beneficiary, or the terms of the will were changed just before the act was committed. For example, should that person still benefit from the estate? So it does come up, and it's an interesting one. And when we talk about how it could apply in Queensland, for example, Queensland, because there's the common law, has a bit of a broader aspect to it. So we talked before about clear examples, I suppose, where someone's charged and convicted of murder or manslaughter. But there's also scope for situations where someone is convicted, I'll use the word quote unquote convicted, of helping another person to commit suicide. So that's another aspect again, and that's an interesting one. And we haven't had, to my knowledge, too many cases, or even any cases about that. But the potential for it to be applied is interesting, and it would come down to the circumstances of the case. For example, if someone helped someone else or helped that person commit suicide, and they stood to benefit from that estate wholeheartedly as the sole beneficiary, for example, you'd have to look at the situation or the events that led up to that suicide act. For example, was the will changed just before, or were they already listed as the sole beneficiary a year prior? So all of these things would play out and would make a difference in court.
Yeah, even the wording, I guess, assist in someone committing suicide. Assist, it's like, what's the definition of that? Did they know? Is that considered as assisting? It really would be a case-by-case situation, wouldn't it?
Yes, exactly. And that's the law. You've got to assess each matter on its merits and a case-by-case situation. So we can even expand it a little bit more. So we've talked about the criminal aspect, of course, in that we're talking about people who might be convicted of a criminal act. And of course, in that situation, when people are charged with a crime, we have that threshold of proving beyond a reasonable doubt for most of the more serious crimes before that person can be convicted. So there's also the aspect that, what if someone goes through a criminal trial and is not convicted? So they actually, so there's no actual conviction. So because, for example, the jury did not find beyond a reasonable doubt that they were guilty. So what happens then? Should that person still stand to benefit?
Yeah.
And there's an aspect there, if you ended up pursuing that person in a civil trial, and there's sufficient evidence that on the balance of probabilities, which is the different threshold, a lesser threshold than beyond a reasonable doubt, if there was enough there to establish that they were guilty, then maybe that would be enough to remove their inheritance as well.
Yeah, wow.
Okay.
Yeah, it's really interesting, isn't it?
Crazy.
Yeah, so this is something that would come up from time to time. But who ultimately is responsible for even triggering such an action? Would the police have to become involved, or family members, or how does that actually start?
That's a really good point, because there is a really good case in Queensland called Pike and Pike. It was a 2015 Supreme Court Queensland case. And in that case, just to answer your question, the applicant was the victim's other son. So the person was charged and convicted of, it was either murder or manslaughter. I think it was manslaughter actually for his mother. And there were two sons. So there's one son that committed the act and was convicted of manslaughter, but the applicant to remove his inheritance was the person's other son, you see, who was obviously not part of that crime at all.
Wow.
And he was the applicant and said, look, he should be removed. I wasn't involved in it. He was charged and convicted, and he should have his inheritance removed. And that was one that was successful, of course. So, yes, to answer the question, it could be another family member to apply for that, or it could be another third party. So, yeah, very interesting.
Very interesting. That is Despina Priala from Boutique Law Firm. And coming up next, the discussion continues in regards to deceased estates. This time we're chatting a bit more about capital gain tax. That's coming up on Talking Law. You're listening to Radio 97.